Oh. Good afternoon. My name is Jim Townsend, and I am the director of the Levin Center at Wayne State University Law School. It is my pleasure to welcome you to today's presentation of a paper entitled Oversight Riders by Professors Kevin Stack and Michael Vandenbergh, both of Vanderbilt Law School. For their work on this article, which appears in the current issue of the Notre Dame Law Review, Professors Stack and Vandenbergh won the Levin Center's second annual award for excellence in oversight research. I want to thank the Levin Center's review committee, which considered for this award a number of really excellent and deserving submissions. The review committee included Wayne State University law professors Bob Ackerman, Linda Beal, Jack Moak, and Hillel Nadler, as well as Professor Stephen Vladeck of the University of Texas Law School, and the co-director of the Levin Center's Washington office, Elise Bean. Thank you for your time and commitment to recognizing outstanding scholarship in the field of oversight research. There is a great deal to be discovered about oversight at the congressional and state legislative level and in the executive branches of government, as well as the larger ecosystem that includes the media and other sectors that enable transparency and accountability, and the ascertainment of important facts that the public needs to know. Never has it been more important that we understand these mechanisms and find ways to protect and strengthen them than in these fraught and dangerous times. We at the Levin Center are pleased and encouraged by the growing interest among scholars of law, political science, public policy, and other fields in doing research on a wide variety of oversight-related issues. And we support that work, not just with awards for scholars and awards for practitioners, but also with non-resident fellowships for scholars engaged in oversight research. To learn more about our efforts, I hope you will visit our website at levin-center.org, join our listserv for oversight scholars, sign up for our newsletters, or follow us on social media. Now, let me introduce our moderator for today's panel. Jennifer Celine last month became the newest member of the Levin Center staff when she joined us as co-director of the Levin Center's Washington office. Jen, as she is known, came to the center from academia. She was a professor of political science at the University of Missouri, and prior to that at the University of Illinois. She has published extensively on administrative law, separation of powers issues, and oversight. Jen, who along with co-director Elise Bean leads the center's Washington office, earned her PhD from Vanderbilt University and her JD from Wake Forest University. Please welcome my colleague, Jennifer Celine. Jen, take it over.
Thanks, Jim. I am really excited to be a part of this panel. I found the paper just incredibly interesting. So what we're going to do is I'm going to turn it over to Kevin and Mike to give a presentation. Then I'm going to follow up with about 15 minutes of questions about the paper itself, and then we'll open it up to questions from the audience. So Mike and Kevin, why don't you go right ahead and start?
Thank you so much. And it shows remarkable judgment that you got your degree from Vanderbilt. So we appreciate knowing that. And it was good to know that you were here years ago working with some great people here. So I'm Mike Vandenbergh. I'm a professor at Vanderbilt Law School, and I'm a co-author with my colleague and friend, Professor Kevin Stack, also at Vanderbilt University, of course, of this Oversight Riders paper. And Kevin and I want to begin by thanking Jim, Jen, Elise, Margot Lespires, the entire team at the Levin Center at Wayne Law. It is a real honor to receive the 2021 award for excellence in oversight research, and we couldn't be any more pleased with it. I'm going to introduce the topic just a little bit, and then turn it over to Kevin to walk through some of the heavy lifting here and present our first rider, and then I will come back and present our second subpoena rider, and we'll wrap up by both taking questions. And we both have been in lots of intense situations before. So both with Jen and with the audience, we hope you'll give us your best shot. We really care a lot about these issues. We want to know what you're thinking and your positive and negative responses to the paper. So the Levin Center, from our perspective, is such a wonderful place to have received an award from, because its mission is to strengthen the integrity, transparency, and accountability of public and private institutions through the promotion and support of bipartisan, fact-based legislative oversight. And so we are just thrilled, because that's exactly what we're trying to do here. And of course, the center is named after Senator Carl Levin, who represented Michigan in the US Senate for 36 years and was a lifelong Detroiter and former member and president of the Detroit City Council. And I thought it was fascinating when I looked at the bio on the website for the Levin Center, which says that during his time in the Senate, he developed a keen interest in making government accountable and responsible to its people through in-depth, fact-based, bipartisan legislative oversight and strong ethics laws. And I think it's fair to say that as we move into a more polarized, partisan world, the ideas of the famous political scientist in the 1950s, Robert Dahl, that social checks and balances are as important to democracy as legal checks and balances, is a critical aspect of what we're addressing. We're looking for how to enable Congress to perform its legitimate oversight functions, even in an era where social checks and balances aren't doing the trick in many cases. So our goal here is to look for new ways, and I think all of those in the audience who are in the academic community, that we all have an obligation to think more about how we bring our academic work to bear in a new world where the old things that we were taught in law school just don't apply anymore. So with that, I want to mention one more thing, because sometimes it's true that anecdotes are better ways to remember things and give us a better sense of who people are. And we are here at the Levin Center. So Kevin and I poked around a little bit, and we're lucky to find Gary Brown here in Nashville, who, when he heard about this program, let us know that he was, and as you may know, Gary is one of the leading securities lawyers in the country, he happens to live here in Nashville. He was counsel to Senator Thompson in 2002 when Trent Lott was the Senate Majority Leader. And Gary remembers Senator Levin as a real bipartisan force. And I think one of the things that came through to me the most when I was hearing anecdotes from Gary about the back and forth between the Republicans and the Democrats at the time was the notion that when he worked for Senator Thompson told Gary to keep an eye on Levin. That was his job early on, but then they quickly realized that the value of bipartisanship was remarkable. And Thompson was told by Levin, look at what we can accomplish when we work together. And the last thing I'll say on that, just to prove the point, was Gary's recollection that when counsel for deponents would come into a deposition room and look around the room and see counsel from the Republicans and counsel from the Democrats at the same table in the room, their eyes would widen and they would realize that they had to take this oversight proceeding incredibly seriously. So I think we see something about the value of bipartisanship. And the last thing I'll say about Senator Levin is that Gary remembers him as a really good guy in a bipartisan way. He recalls being in a Senate committee room late in the night, working on something during the financial meltdown investigations, and Levin poking his head in the room to this bipartisan group working and saying, "Have you all had dinner?" And everyone saying no, and Levin coming back not long afterwards with Chinese food that he had gotten himself for the whole group. So sounds to me, I didn't meet Senator Levin, sounds to me that he was not only committed to bipartisanship, but understood the human glue that makes all this possible. So it's just such an honor to be here. And with that, I'm going to turn it over to Kevin now, and then I'll come back at the end of the program. Kevin?
Thanks so much, Mike. I want to reiterate our thanks to Levin Center, and it's been wonderful working with Mike on this project. Really delighted to get this recognition and have this opportunity today. So, I think the premise, in a way, is it's hard to think of a more important topic, as Jim and Mike have been talking about, than oversight and how Congress gets access to information about how government's working. And our paper is really premised on the observation that the executive branch has been playing hardball with Congress on compliance with oversight and largely winning. And the result is a pretty entrenched pattern of stonewalling of Congress's legitimate requests for oversight. And our paper is really meant to address that. So how we do so is we identify what I think we could say a newish way of trying to skin the cat of oversight here, using appropriations powers as tools to create additional incentives for the executive branch to comply with congressional requests for oversight. So returning to oversight, I think we are trying to put into action the observation recently made by Jillian Metzger that appropriations is a really important and sometimes neglected tool for pushing back on the imperial presidency. So I'd like to say at the outset that the tool, this newish idea of using oversight is not a complete answer. These are really hard problems, but we hope it makes an incremental contribution to the problem. So for this audience, I'm not going to belabor the idea that oversight is important to evaluating how the executive spends the funds that Congress appropriates. It's appropriate, to inform Congress about legislation as it's enacted, and important to create accountability mechanisms in the executive branch, right? It's also important because the prospect of oversight will deter some executive misconduct. Nor am I going to belabor the point that Congress has constitutionally grounded, recognized as statutorily supported powers of oversight, right? They have a power of inquiry and the process to support it that's constitutionally grounded. We can get more into that in question and answer if you want to. And Congress has really acted on that power, creating structures and standing committees and authorizing the structure of oversight. So despite that, the executive branch has been resisting oversight and winning in that resistance. And I think oversight conflicts follow a pattern that's going to be familiar to other members here today. So Congress, a committee will initiate a request for information from the executive branch. There'll be some negotiations, likely, then continued resistance after a while, maybe if it's significant enough, the issuance of a subpoena, continued resistance, often invoking executive privilege, right? And with that, at that point, often if it's not important enough to Congress, the controversy just dies there. But when the stakes are high enough, kind of having reached a point of impasse with negotiations, Congress will then, or committee, will turn to the courts to try to litigate and get a judicial judgment enforcing their constitutionally vested powers of oversight. So a couple examples, and there are examples of this across administrations, in Republican administrations of resisting Democratic oversight, and in Democratic administrations resisting Republican congressional oversight. That happened in the 80s. We give examples of the paper of when Ann Gorsuch was the administrator of the EPA, resisting EPA enforcement, ultimately resulting in long delays as well as other legal actions. It happened during the Obama administration, where there was a back and forth, extensive back and forth between Congress and Attorney General Eric Holder on the Fast and Furious program. That resulted in delays in disclosure about the facts of that program. And there are also numerous examples during the Trump administration. So the kind of overall takeaway is that Congress has been turning to litigations with really mixed results, but most importantly, almost always extensive delays in disclosure, which undermine the value of congressional oversight. So the paper turns then to the question, well, so why is Congress continually losing these battles? And so to do so, let's just sort of step back and think about, well, what is the toolbox that Congress has that it can use to try to get information from resistant executive branch officials? So first, there's Congress's inherent contempt powers, and in Josh Havitz has a wonderful book on Congress's Constitution where he documents carefully how Congress had a long history of using its inherent contempt powers, literally having its own officials go out and seize and take custody of executive officials. That prospect of inherent contempt, Congress is allowed to atrophy, I think, on the thought that there is something inherently difficult and unseemly about a congressional marshal and a U.S. marshal in a face-off over whether a department, say a Department of State official, should come and be seized by Congress. So that's no longer actively used. There is the prospect, there is a criminal liability. Congress enacted a statute which allows DOJ to bring criminal sanctions against executive officials when they're in contempt of Congress. But that also is that DOJ has been very reluctant to bring criminal sanctions against executive officials, many of whom are resisting based on assertions of executive privilege that the executive branch has itself embraced. So that hasn't been working. Third approach is the most commonly pursued one is civil litigation, which, as I've mentioned before, has been a long and winding, and really at the bottom of it is just a process full of delays and uncertainty. The fourth approach would be sanctioning agencies' budgets. So there are examples of Congress directly sanctioning agencies' budget in response to recalcitrance from executive branch officials. So in the Obama administration, there was a back and forth with the IRS about whether the IRS was targeting politically conservative groups for scrutiny as to their qualifications for tax exemption. That resulted in a standoff with the IRS, and then later Congress went back and sanctioned the agency and its budget. Problem with this approach, it's a little bit broad, and it's also after the fact. It didn't actually end up resulting in the disclosure of the information the Congress seeked. So here's the thought we had, which is, well, Mike and I were brainstorming. Well, could there be a more targeted way to provide executive officials ex ante incentives to comply with congressional requests for subpoenas, right? And the ex ante is really important, which is not an incentive that would kick in before litigation, right? That was a kind of critical piece of this. And so we found, so that got us thinking, and we came to the idea of some sort of appropriations sanctions. And so we found one appropriations rider, an existing appropriation rider that does some of this kind of work. And it's called the Section 713 Rider. And the rider has a pretty long history. It was originally developed in the context of the Postal Service. The Postmaster General had directed that only one official in the congressional liaison, in fact, could communicate with Congress. And Congress didn't like the idea that the Postmaster General could restrict their communications with other members of the Postal Service, and so they enacted a version of this rider, and then it eventually became a government-wide rider. So let me just point out a couple of features of it. So what it does is it says no appropriated monies can go to pay any official of the federal government who prevents or threatens another official from basically giving information or testimony to Congress, right? And so it disappropriates that, and it says, in fact, then that it gives a salary sanction. There can be a salary clawback for any official who thwarts Congress's ability to obtain testimony from other officials. So this rider has a couple of different features which look pretty appealing, and overcoming some of the structural barriers that we've seen in the other sets of congressional tools. So it creates an incentive that's personal to the official, right? There's a salary reduction, right? A salary reduction for resistance, right? The investigation is a public investigation, so that can have a public sanction, right? In a world where those kind of public sanctions matter, right? It's not dependent on DOJ to engage the investigation. Congress itself can reach out to the Government Accounting Office and trigger an investigation as to whether the rider has been violated. And GAO is beholden to Congress, not GOJ investigation. And that there could be a pretty long-term duration. GOA has interpreted these violations as continuing violations. And so you could have a violation that would continue for an employee over and beyond one term of administration. So pretty consistent. So in principle, it looks like the rider would solve some of the problems we were trying to solve, which is creates ex-ante incentives for officials to engage in ex-ante officials, which is their salary, not to thwart the communications of members of the executive branch with Congress. So in practice, it hasn't worked out that well. Basically, we think it's been largely neglected, right? And over the past 20 years, we're only aware of 2 GAO investigations that found violations. The one was GAO recommended that the administrator of CMS be found in violation in 2004. And in 2016, GAO found that HUD, a deputy assistant secretary, had prevented communications with the committee for 15 days and ordered a payback of his salary. It also surfaced in the Trump administration, but didn't have much traction. So our question then would be, which then sort of prompted, well, could we think about whether there could be a rider that would be designed more specifically to target non-compliance with congressional subpoenas, right? That would build on some of the idea of getting an ex-ante incentive we see in the 713 rider, but maybe do a little more. So some limitations of the 713 rider is it only targets supervisory action, right? It's limited to a salary clawback, right? And it doesn't, target non-compliance directly. So that got us thinking about how we could develop a rider that was really focused on subpoenas. And so with that, I'm going to turn it back over to Mike.
Great, thanks, Kevin. And with that, it's the perfect time then to turn to our subpoena rider, as we call it. And here we have one. You can see it's designed around the one Kevin just walked us through, but no part of any appropriation contained in this and any other act shall be available for the payment of the salary of any officer or employee of the federal government or used by such an officer or employee to refuse to produce on a timely basis documents or testimony subject to a subpoena issued by a committee of the House or Senate, or to facilitate such conduct. And then also you see the other language: to plan for, begin, continue, finish, process, etc., preparation or presentation of false or misleading documents or testimony. And so what are we trying to accomplish with this? And what we're trying to do is fill in the gaps, perhaps, as Kevin just mentioned, of what we saw in the 713 rider. So what does this do? What it does is it makes the official's salary contingent on compliance, like the 713 rider. It's consistent with the GAO interpretation of the 713 rider to make salary clawback begin on the date of non-compliance and extend through compliance. So the violation is understood to be a continuing one. It, like the 713 rider, it doesn't depend on the Department of Justice's initiative. So if you have a different executive branch from Congress, you don't lose the likelihood that it will get enforced on some level. And a member of Congress could trigger a GAO investigation, and this can occur more quickly than litigation as well. It also inverts the party likely to seek judicial review, which could be very important. So it's the executive official, not Congress, that will likely seek judicial intervention. And that overcomes the traditional obstacles that Kevin has talked about to Congress or congressional committees litigating as plaintiffs. In addition, it brings in the Anti-Deficiency Act. So the Subpoena Rider triggers the Anti-Deficiency Act by prohibiting the quote unquote use of funds appropriated to resist subpoenas as well as any time and effort spent on resistance that involves the use of funds then would potentially cause risk on the Anti-Deficiency Act. And one of the things that I mentioned as Kevin and I were working on this paper is how much what we know from the deep literature on compliance with law, Gary Becker's Nobel Prize winning work and others, is that the goal is to create the perception in the target community that the likelihood of detection times the magnitude of the sanction will be greater than the benefit of non-compliance. And so in all of these areas, what we're not arguing is that these are perfect remedies, but that we're looking for additional ways, even in a deeply divided government, for that probability of detection times magnitude of likely sanction to be high enough to induce a level of compliance that's consistent with Congress's oversight role. So just a couple of thoughts then. Let me just keep going here. So what about the Anti-Deficiency Act? Of course, it dates from 1870, was enacted to prevent executive branch officials from spending beyond the monies appropriated for a fiscal year and later seeking a deficiency appropriation from Congress. And the act makes it unlawful for government officials to, quote, make or authorize, end quote, an expenditure that has not been appropriated or to work without an appropriation except in emergencies. So the Anti-Deficiency Act thus prohibits any officer or employee from using funds, including funds expended by working on the federal payroll in a manner other than appropriated. And the act requires that violations be reported to the head of the agency, and then the head of the agency shall report immediately to the president and to Congress. So the report then that has to be signed by the agency head has to explain the violation, how it occurred, and its effects on the agency and any remedies taken. And the act authorizes administrative discipline, including suspension without pay or removal from office. And it also includes a provision for criminal penalties that are knowingly and willfully violating the act. So even though there's not a prosecution that we were able to find that's been brought to date under the act's criminal sanctions, we're entering a new world now. I think what we're going to be seeing over and over again are extraordinary efforts that are designed to re-establish the balance of congressional oversight. And the mere existence of criminal penalties might trigger that Becker formula that I mentioned, might raise the stakes enough that the perceived benefits of compliance are greater than the benefits of non-compliance. And lastly, questions about executive privilege are ones that I think I'll let Kevin address. He's more of the expert on that. But with that, let me say a couple of limits here that we see with this. I'm uncomfortable as a former agency official myself with overuse of appropriations as a way to achieve substantive outcomes, whether those are authorizing type outcomes or oversight. There is a great deal of literature that suggests that the appropriations process is not the most deliberative way in some areas to bring expertise into the process. So we're aware of that. Second, the feasibility issue is you still must have an appropriations bill in order for this to work. But of course, appropriations bills tend to be more feasible than authorizing statutes. In the environmental area where I'm an expert, for example, we haven't had a major statute with the exception of the Lautenberg Act in 2016 since 1990, a major pollution control statute. So appropriations bills are moving in ways that perhaps some other legislation might not if it were required. There are potentially limited effects on obstruction by non-government employees. What we're really able to do here is bring this to bear on government employees. But as we've seen recently, non-government employees may be important too. We don't really reach that in a direct way. Maybe most importantly, to the extent that there is obstruction or misbehavior that doesn't involve something that arguably includes expenditure of monies, then you run into a limitation here that maybe you don't trigger some of the sanctions that we're trying to trigger through the Anti-Deficiency Act. And of course, that also raises this question of the fact that we just haven't seen a lot of enforcement of the Anti-Deficiency Act in the past. But again, my own view is that over the next 10 to 20 years, we're going to see a lot of extraordinary activity because we are entering a new world with extraordinary polarization that we haven't seen since the Civil War. And then, of course, there is a risk of misuse. You can use appropriations riders, subpoena riders in an effective way to achieve fact-based oversight, or you could use them to badger agencies. And so it will be, this is a risk of developing this tool. And I'll wrap up before I turn it back for Jen and for questions to Kevin and me with some areas where we might extend the rider idea, the oversight rider idea. And one is political activity. Of course, the Hatch Act prevents certain kinds of political activity by executive branch officials. And of course, you could design riders that were targeting the very limited enforcement that has occurred of the Hatch Act over time. Similarly, ethics issues, conflict of interest, gift receipts, a range of other different activities where it seems as though in the absence of the social checks and balances that would otherwise cause shaming and enforcement of ethics rules, there is fairly limited legal enforcement of these ethics rules, except in the most egregious cases, and perhaps an oversight rider type design might make some sense there. And then lastly, transparency, Presidential Records Act, Federal Records Act, FACA, National Environmental Policy Act, FOIA, all the different ways in which Congress has attempted to allow information to be a way to constrain behavior in a functional democracy get more difficult in an era of deep polarization. So perhaps riders could be a tool to reinvigorate the transparency aspects of accountability as well. So those are areas we didn't develop in more detail, but we can see over the horizon a little bit, assuming you think that oversight riders are a good idea. And for that, let's toss the ball back over to Jen.
Sounds good. Okay, so thanks so much for your presentation. And there's so much to like about this paper. I think one of the fundamental principles of American governance is that each branch of government really has the necessary constitutional means and motives to resist the encroachment of others. And oversight is a really important part of that system. And one of the things that I was thinking about as I was reading this is that it's interesting that the legislature's constitutional authority to investigate is in part grounded in its appropriations authority. And so this paper is interesting because it's drawing on Congress's appropriations authority, which originally, as I just said, it gives the legislature its investigative authority. And another really interesting thing that I thought of as I was reading the paper, and then it came out even more clearly in your presentation, is I've always liked this idea of like thinking about contempt and subpoenas, because of the three forms of contempt, each of them relies on a different branch of government for enforcement. So inherent in contempt relies on Congress, criminal intent tends to rely on the Department of Justice, and then civil contempt on the courts. And of these three forms, as you guys highlighted, really Congress has let its own form of enforcement go, which is an interesting thing to think about as well. And so as I was reading the paper, most of my questions can fall into two categories, practical and theoretical. And so I'll start with the practical stuff because looking at the question and answer, or the questions that have been popping up in the chat thus far, people do tend to have some questions on the practical stuff. But as you guys hinted in your presentation, what you really wanted to do was provide an ex-ante incentive up front. And in this sense, any information negotiation between the branches is really part of an iterative game where each player anticipates the actions of the other. And it is possible that the executive branch has learned to play this iterative game better. And so what we're trying to do is sort of fix that. And so if we're thinking about information requests, it's important to acknowledge that these requests I think of them as two stages. First, you have the legislature's decision to request information in the first place. And that in part, like it or not, is informed by the likelihood that they think that they're going to get the information or that they need it. Then there is the executive's decision to release that information. And it's this part that I want to focus on here. Who is the person who actually makes the decision not to comply? It's not necessarily the individual who is subpoenaed. And so as I was reading the paper, that's one thing that I kept coming back to. The individual who's not complying under this scheme might be stuck between a rock and a hard place. You have the potential of losing your salary for not complying, but then at the same time, if you're a political appointee, there's a real chance you could get fired. So what are you supposed to do? Assuming that we're talking about appointees and not career civil servants. So
I suspect we both have
question.
Yeah, I suspect we both have answers. I'll give one, Kevin, unless you want to take the first crack at this one.
Oh, no, I'll cover that.
So I think of this from the perspective of the famous notion that an employee has three options in an employment context: exit, voice, and loyalty. And my view would be, yes, you're going to find some situations, if our rider is used widely, where an employee is put in a position of having to make that choice, and they aren't even the one who necessarily made the executive decision. They may be being told by someone else. And I guess my simple answer is our form of democracy is at risk now. And if that creates the need for people to exit, or to express their voice, then that's an appropriate trade-off. And it will cause some unfairness to employees, but the harm to our democracy generally is far greater than some people feeling as though they have to leave. And I think the process of that occurring can contribute to effective oversight of government. So I'm sympathetic, but I think we're in a zone now where there are going to be trade-offs. There is no painless process. And so I'm personally okay with the idea that there will be times where people will either have to go public and say, I'm being told not to do this, I wish I didn't, and get fired. But that the downside of a process in which one branch can no longer oversee the other, despite its constitutional authority to do so, I think is just unacceptable. Now, Kevin may have a softer answer to that. That's a pretty tough answer.
But maybe I'll just maybe talk about a little different aspect of it, which is, if you think about how this is going to operate on an official, there is going to be, I think we can see that this is not just second best, this is like a third best world we're in, right? And so we're thinking about the strategic here. And so when you talk about the effect on official, yeah, it's going to be a collective decision. It's not going to be the individual line officer it's going to be a collective executive branch decision, which I think that actually the fact that it's a collective decision means that the rider actually might have greater traction of having some efficacy, because there's going to be more time than many spent figuring out what the scope of compliance could be or won't be, right, on the one hand. But I guess the way we imagine it working out would be, it gives the official an incentive to investigate the scope of the claim of executive privilege that the Department of Justice has asserted, right? And if it's a wildly broad claim, they know in eventual litigation that they're going to be on the hook for it. It gives them an incentive to sort of, right now, there's currently no incentive other than, kind of broad shaming for an executive official to check how broad, or even to inquire as to how broad an assertion of executive privilege is. And this sort of puts a little bit of stake for the individual official to say, sounds a little broad, and I might have some skin in the game on this, right? So that's sort of maybe another way of coming at the answer of how the dynamics going to work out with the official.
So then can you walk me through on this executive privilege, sort of in a world where we're claiming executive privilege, say, under the current scheme, in order to contest the congressional request, the executive official first has to refuse to comply and then provide the defense. And then if the two branches can't come to an agreement, then you pursue criminal or likely civil, end up in court. But where in the process is the defense being asserted? Is it upfront? Is it with at the same time as refusing to comply? And then what is the timing and the process of the GAO's investigation? If you could just sort of walk for someone like me who just very bullet point, first this happens, then this happens, then this happens. That would really be helpful for me.
Yeah, that's great. I don't know, Mike, should I start this one?
If you would start it, I'm happy to add gloss as we go.
Michael, correct me if I go wrong. So, so I think that the setup is the same, which is Congress requests information, right? And the executive branch resists. And the executive branch, there may be negotiations, but eventually after failed negotiations, the resistance is grounded in executive privilege, okay? And in the current scenario, as I was just mentioning, the executive official, that's sort of the standoff. That's the standoff, and then Congress has to go to court. Now, the executive official would be resisting based on a claim of executive privilege, and the executive privilege and the money spent thinking about that resistance, right, and compliance with the executive branch's advice on executive privilege, right, would be not appropriated, right? And so that official then would be, that time and energy would be violating the Anti-Deficiency Act, right? And that salary time would also be subject to clawback. And so then I think at that time, then Congress could initiate a request to the GAO if it kind of played out the same way that the 713 rider could initiate a request to GAO on that hand, but at the same time, the official might have an incentive to seek the advice of counsel, right? Which is say, is the scope of executive privilege here within the domains of reasonableness? If it's within the domain of what's a reasonable, judicially authorized understanding the scope of privilege, well, the executive official is likely to be safe. If it's wildly more broader than what most courts recognize, in which some assertions of executive privilege are, right, then the official's got to realize that this claim may not be upheld, right, in which case the time and energy spent will have been unappropriated, and there'll be subject to a clawback. So that's sort of the way I would imagine the kind of nuts and bolts.
I agree, and my guess is, and this is one of the wonderful things about the Levin Center, my guess is that people you have on the call here include people who have a more detailed knowledge than we do. We did our best to uncover this. We're in the academy. We have every incentive, as you know, the first probably 10 papers I wrote, my senior colleagues told me, take out all the feasible stuff at the end there. And so we've actually tried really hard here to meld the feasible with the theoretical, but I guarantee you've got people here in the audience who know this at a level of nuance that's greater than ours. And we'd like to hear that, by the way. We may do something else on this in the future. So we're very happy to take both positive and negative feedback on how this would play out on the ground level.
And to that point, one of the questions that we've received is if you could talk a little bit more about the GAO investigation process, like who triggers it, what happens, how long it takes, does the executive branch official have the ability to provide evidence to GAO, is DOJ involved, those sorts of questions.
Yeah, I can start on this a little bit, just to Mike can fill in a little bit, which is that you know, where this paper led us was to look at the investigations under the 713 rider, right? Mm-hmm. And so those riders, those investigations were initiated by members of Congress, right? And so and then GAO took them up. And so one of the things we were looking at was, well, is GAO any faster than going to court, right? Is this GAO investigation any faster than going to court? And the two investigations we found, although not lightning speed, were faster than much litigation. So, and that's also GAO, because it has such, it's accountable to Congress directly. I think if it was going slower, Congress could say, in general, we want these investigations completed within 4 to 6 months. So the two investigations were relatively speedy. I'd have to look exactly at the top of my head exactly how long they were, within a matter of months or maybe a year and maybe a smidge. So that's one question. And then I have to say, I'm not sure that I know that much exactly about who's involved in a GAO investigation, whether the people who are investigated retain counsel and those kinds of things. And would love to learn more, actually.
Yeah, I'm in the same place. And I do think, again, like I've said before, we have the world as it has been over time. How has the GAO conducted investigations? And then we have a world in a deeply polarized government. And what we might see that would be most relevant might not even be what happened over the last couple of decades, but more how could these be done in a world in which Congress needs to exercise this kind of authority to get its legitimate oversight completed. And so what I like about these approaches the most is that they do undermine the ability of a divided government to prevent oversight from occurring. And they do provide, again, one additional increased ratchet on that perceived likelihood of sanction by the individual. And so I think those features here, to me, dominate over the mechanics of the processes but I think we should be aware that however the process has been so far, we don't at least see design features that couldn't accommodate a quite rapid process moving forward.
And so I want to go back to this idea of like, this is an iterative game and the Section 13 rider itself. So as you said, in the past 23 years, you could only find two of these violations and investigations. My question is, as an empirical political scientist, we're looking at the two things that we can see. So how often was GAO asked to conduct investigation? And are we making the assumption that this rider is not being used because it's somehow problematic, or is it that it is in place so much that it doesn't have to be used, which I don't think is the case, because otherwise, why would we have denials of like of information requests in the first place. But do you see where I'm going with that?
Absolutely, absolutely. And we know from regulatory enforcement generally that often if you try empirically to connect a particular regulatory program or enforcement program to a particular outcome, it's certainly true in the environmental area, it's incredibly difficult to do, even though we can be quite confident that they're having a real effect. So that could be going on here. I refer to Kevin on this, but I didn't get the sense as we looked at the literature over time that people are even aware of this in a lot of cases. So it doesn't feel as though it's the kind of thing where it's being used as a club that is over the shoulder and people are behaving differently because they're afraid they're going to get clubbed by it. It's just not used. That could be the case, Kevin, but I don't recall us seeing any evidence that that might be true.
Yeah, I think it's a great question, Jen, which is, maybe this is in fact creating incentives to negotiation, right? But my looking around in it, it really seems to have fallen into obscurity. And happy to be corrected on that. And maybe one sort of example would be, I think that it could have been actively used in the Trump administration, right, by the oversight committees, which is, and there wasn't much traction on that. So there's some reason that I don't think it's this secret, strong kind of access point that's forcing people to engage in negotiations so we don't get GAO investigation. It seems to have sort of just fallen into desuetude.
So also going back to this GAO, this is we're transitioning now from my practical to my theoretical stuff. But I was one of the things that I was thinking is ultimately all of these questions are separation of powers questions. They're big balance of power questions. And do we have a separation of powers concern if an arm of Congress is defining the parameters of executive privilege? Now, I mean, right now, we essentially have the executive defining the parameters of executive privilege. So I do recognize that is there. But I was puzzling over it, and I could see either way. I could make an argument either way. So I was kind of wondering what your thoughts were on that.
Sure, should I take this one, Mike?
Yeah.
So you're exactly right. That currently we have the executive branch is able to assert executive privilege, and then that creates, with slow judicial enforcement, creates enough delay. And as we were initially thinking about it, we thought a little bit about, well, could we have a way of fast tracking judicial enforcement or judicial review of executive branch assertions of executive privilege? And why we didn't go that direction was we felt like it was not feasible to have the current Congress engage that. So whereas Appropriations Act are passed every year, it really is a tool of self-help for Congress if we can create some ex-ante incentives. So one way in which I think about this is if an executive official has a reasonable basis to believe that the assertion of executive privilege is correct, well then they're going to have confidence that that's what a court would ultimately hold. So they can, if there is a movement to claw back their salary, they could initiate a lawsuit, or even before maybe, right, and a lawsuit would adjudicate whether that was a valid clawback, and that the validity of the clawback would depend upon the validity of the assertion of executive privilege. And if it was a valid assertion, even a reasonable assertion of executive privilege, there would be no liability, right? But we're in a scenario where not all assertions of executive privilege are reasonable. In fact, some are quite overbroad. And so for that official, there would be, this would create an incentive. Now, does that unconstitutionally burden the assertion of executive privilege? I don't think it does, right? But that's I think that's the kind of nub of the constitutional issue, whether creating an incentive to comply would somehow burdens this unspoken privilege, right? Recognized but unarticulated. Mike, do you want to step in?
Yeah, I have a thought on that. And it's completely consistent with what you just described. I do get what you're talking about, Jen. I think a little bit about the DC Circuit. I think it was Judge Williams before Whitman versus American Trucking, where essentially the argument was EPA can constrain its own delegation of authority. If it does so, we can avoid non-delegation problems. And of course, Justice Scalia there said, no, that in and of itself is an exercise of your discretion. And there's so I get your logical argument, makes total sense to me. I guess the point I would say is, given what we know about the practicalities of the slowness of courts resolving these claims, executive privilege has expanded to the point where it's essentially an atom bomb that prevents, in some cases, legitimate oversight from occurring. And so I don't see this as Congress inappropriately stepping into the role of the executive. I see it as a way to create some pushback that will allow us to have a reasonably constrained version of executive privilege that still exists, absolutely, but that is not inadvertently using timing and delay as a way to make executive privilege essentially override this otherwise very important interbranch function.
If I could just also, I don't know, Jen, if I could add one more thing there, we rely in part on the idea, this is an idea put forth by Zachary Price, about how do we distinguish the constitutionality of claims of presidential power from claims of Congress's appropriations power. And he makes a distinction between, well, is the president doing something that's resource dependent, right? Or is it a resource independent action? And he says for resource dependent actions, right, there's the president is really beholden to the limits that Congress places on appropriations. So that's another way. Everything we're talking, a lot of what we're talking about here, at least most of what we're talking about, is resource dependent action. These are review of executive action authorized and appropriated in every agency by Congress. So totally resource dependent. So that's another way of kind of slicing at the constitutional issues.
And I have one short last question based on that last little response there, and then I'll start working through the question. Stop hogging time, because I have like several pages that I could. but so on the subject of like appropriations and resources and whatnot, and given my scholarship on agency structure, I was wondering, what do we do with those agencies that don't rely on congressional appropriations?
Well, you got me on that one. I don't have anything for you. Kevin is light years ahead of me in some of this literature and thinking, so I'm going to defer to him and pass the hardball in his direction.
Sounds like a limit to Jen that we should have talked to you first. So our structure is completely dependent on those agencies that are appropriated, and so agencies that have sources of funding that are not appropriated, right? That we're not going to be able to reach their resistance to congressional oversight.
Right, and maybe one response, Kevin, this may be where you're going, but is we are probably also less worried about those agencies. If part of the problem here is sort of political hardball being played through often White House, through OLC type pressure, those agencies may be a little more insulated from that in the first place. So maybe this is less of a threat. The second thing I would say, just because a lot of the way I think about these things is that the social norms of compliance often dominate the legal norms. And if we can shift the norms of noncompliance a little bit, that might create greater pressure when someone does act in an extraordinary way to avoid oversight, because the general norm in Washington might shift back a little bit more in the direction of course you're going to comply unless you have a supremely good reason not to. So maybe we can get more in a place where media coverage and general social checks and balances will have a little bit of a bigger effect. But I still think that you got us on that one.
Well, and I honestly don't even think it's that big of a deal, because I mean, as you said, most of the agencies we're talking about here are political. But then if you want to play the other card, like if you look at the flip side, actually maybe we should be even more concerned, because those same agencies that are able to raise their own funds tend to operate outside of other levers of political control as well. And so we might not be able to acquire the same amount of information on what those agencies are doing, simply because the tools of control are limited in various ways. And then if we're trying to strengthen Congress's ability to acquire information, then again, so yeah.
One other just thought is that they probably less often have even a colorable claim for executive privilege. If they're in theory insulated from the president, it's going to get harder for them to make that argument. So we're a little less worried about their ability not to comply. Yeah.
Well, and with that, I will start working my way through everyone else's questions. So we hit that one. So did you consider building in an exception for a presidential invocation of executive privilege, given that DOJ would undoubtedly argue that it's unconstitutional to penalize a subordinate executive official for withholding information at the president's instruction?
I'll start talking and Mike can, no, I don't think we did. Or maybe we considered it, but we didn't adopt it, which is I'd be worried that in these kinds of times, there would be, that would just create a funneling of executive privilege claims through the presidency. And so therefore, regardless of the merits, effectively, they would get kicked up to the president and then back down. So I worry that would be too broad. But I think the question, thank you so much for the question. But I also think it goes to that this is really, we're trying to put direct incentives on public servants, right? And that's not a great, I want to be really forthcoming. That's we only came to that after we'd excluded every other possibility, right? So there is a kind of, this is, I think, tools of constitutional hardball, right? And so it would be that there are going to be tough choices faced by some executive officials if this rider were to be passed. Or I want to say, if one product of our paper is the 1713 rider gets a little more traction, well, that's also pretty, I think that's valuable too. It'd be valuable to Congress. Clearly, the paper is a strongly congressionalist paper. And to kind of dust off the 713 rider, well, if we had any role in that, well, that would be a huge victory too.
Yeah, as a general rule, the old dictum that hard cases make bad law, I think polarization and partisanship makes bad interbranch relationships and makes for hard trade-offs. And again, as Kevin said, we don't love where we ended up on this. And what we're going to have to all do is to say, in the big picture sense, what are we willing to give up in order to give some level of balance and the use of legitimate oversight here. And people may conclude that this is too far. I think ultimately as well, the Supreme Court is going to need to decide, is there some level at which some harm is worth occurring in order to constrain whether it's executive privilege claims or whatever it might be. But we're playing for keeps here, I think. And when you look in a lot of different areas, we need to have the ability to legislate. We need to have the ability to get documents and get them when there's misbehavior or information that's relevant to the authorizing process, get them in the time necessary for them to inform the authorizing process and in the time necessary for the public to hold the executive branch accountable. That's what the democracy is all about. And if you cannot produce documents in time for the public to know what you did, then the notion of voting for one candidate or another is undermined in a very substantial way. And so we will just need to see. It may be that the Supreme Court doesn't ultimately find that to be what's triggered here, but I think ultimately that's what's at stake. Are they going to police the boundaries of these processes in a way that allows us to keep a system that represents the views of the majority of the American population through the electoral process?
And building off of both of your answers to that point, I'm going to combine a question that we received and one with my own. So each chamber's first investigations in 1792 in the House and 1818 in the Senate involved an authorization of a committee to collect papers and persons and records as may be necessary. And overall, Congress was pretty much able to acquire the information it needed. And in this regard, little has changed if you think about the daily interactions between Congress and the executive branch. So your paper is really motivated by these egregious examples And it starts with the presumption of conflict. But is that actually true? So obviously the Trump administration's extreme positions on noncompliance has really heightened attention to the issue. But how serious of a problem are we actually talking about on a day-to-day? Is the level of noncompliance we're seeing on a day-to-day equivalent with other points in history?
So I'm not an expert on the frequency, but I would say that I don't think the frequency is the question. It doesn't really matter how much is going on day to day. What matters is in those big inflection points where democratic accountability is in play. And to me, that's when there needs to be a tool. I think day to day, is it worth doing these? I personally would say probably not, in the sense that I don't like the idea of using the appropriations process in this way in the first place. So if it were done just as kind of a routine matter, that would trouble me. I think the key is when you have truly dispositive issues, then Congress needs this kind of power. So from my perspective, the question isn't frequency or regularity so much as, is it a tool in the toolbox that can be pulled out when it's time for third best options? Now, Kevin may have a different view on that. That's not something we've really talked about.
Yeah, I think it's a good question. I guess I'm deeply concerned about, insofar when we have divided government, right? There's pretty strong incentives for about the kinds of actions where there's real concern, not day-to-day understanding what's going on, but the kinds of action where we're really worried about, well, has there been some wrongdoing, right? Or the executive branch might have an incentive not to disclose it, right? Those kinds of circumstances, to me, it feels like over time there is a breakdown of back and forth cooperation. And so at least in those cases, which I think are salient and important to have Congress as a forum to vet politically, right? This could be an important way. So I'd be happy and I'm pleased to think there's a lot of day-to-day cooperation, but when you have, but you need a bigger tool, maybe, as a thought, when you have exactly the kinds of disclosure that the executive branch might resist doing, which is going to be things that are embarrassing and don't reflect well on them.
And now turning back to the practical everyday. So one of the questions is, are there any due process issues we have to be concerned about here with ex-ante salary withholding, giving a disputed claim of executive privilege?
That's why, from my perspective, I like the idea that one thing that the Administrative Procedure Act, and Kevin is again more of an expert than I am on this, but it gives you is, if that's your view, you have boom, access to the federal courts quickly, and that's your place to make that claim. And that by flipping who the litigant is, you're, I think, at the core of just judiciability type issues. I think you can get that heard by a court. But Kevin, again, that's more of your area of expertise.
I think that it's a great question. And I would have a two-prong response. One prong is that is what Mike said, that post deprivation judicial remedies are sometimes sufficient in due process to satisfy due process. But I think there's also pre-deprivation adjudications here, which is there's investigations conducted by the GAO, which are reasoned based on evidence, and there's a record, right? And the Anti-Deficiency Act also has a formal process. So I think that it's likely that those formal processes would satisfy our demands for due process. That's sufficient process along the way, right? And then I guess my secondary argument would be there's also the possibility of resort to the courts pretty quickly. But I think it's the due process question is a great question. Thanks for asking it. And that's the way I'm sort of thinking about it.
And on the opinions of GAO on these sorts of matters, how did you find the two examples of the 713 rider? Was it a published opinion from GAO or?
Yes, I think that was research. I'll say I'm not recalling immediately. I think it was research in the GAO research, I could look a little bit. We've got some good, nice footnotes in there. And the way things work is you write the article in the summer. If you're lucky, it comes out in the fall, and here we are in the spring. So I'd have to refresh a little bit about exactly where I found that's.
Right.
But there's some good documentation in the article about the rider, and whether I found it through. The sources I'm citing are GAO letters.
Right.
So we're citing a GAO letters. So I think it's GAO research. Sorry to be a little
Right.
long.
Well, I would just say, as you can tell, Kevin took the lead on that. And I would just say a couple of additional things, which is, number one, we do have extensive footnotes in there. There's no problem finding things. And we, of course, have copies of those. So if someone is having trouble finding them, we're happy to make them available. In addition, we didn't have any extraordinary powers here. We had ourselves plus some law student and undergraduate research assistants who did nice work for us, but they weren't, particularly trained in these areas. So these kinds of documents are available to the average researcher if you do a little hunting.
Then if we're thinking about if you wanted to challenge a GAO decision in court, what would the record be? How would that work? They would have to issue an opinion, right? I mean, the GAO would. Yeah,
I think you could do. I think there would be a GAO decision, and there's opinions. Certainly, the clawback decision I mentioned was a written decision, and so I think that would be agency action under the Administrative Procedure Act, final agency action. And so, as final agency action, there are a couple other barriers, but we clearly would have standing, so I think it would be. The Administrative Procedure Act would provide a cause of action for that. So I think there would be pretty fluid, as Mike was mentioning before, pretty fluid ability to contest that agency action. Now.
Okay, and then presumably GAO could find that the executive branch has reasonably claimed privilege.
Right, and that's exactly within the realm of what we contemplate here, where our goal is not to truly have any effect on the scope of legitimate executive branch privilege, just not to allow claims that are well outside the plausible realm, combined with the delays in federal court action, to essentially make it an atom bomb in the process.
Mm-hmm. Yeah, and we have sort of reached the end of the questions that we've received. There's a little bit of time if anybody has any last minute questions that are burning to ask.
I guess one question I'd like to provoke, in case you don't have others, and maybe you have thoughts, which is, I'm very interested in the next round of application of these. Mm-hmm. Would it make sense to think about Hatch Act type riders? Would it make sense to think about ethics and government type riders? What about compliance with various kinds of record keeping and transparency? Or would it be a mistake to go down that road and to use the appropriations rider process to essentially create a parallel set of requirements to try to enforce the existing statutes in a more effective way? Is that a good idea, a bad idea? Your reactions to that, I think, would be quite useful.
Well, my initial reaction to the paper, and then also looking at the questions that were asked, and I did miss one, which I'm bringing up right now. But if you were looking for an extension, I think really providing, talking to GAO and getting a better handle on GAO's perspective on all of this and how that would work, and setting up that framework, telling the story from GAO's perspective, as opposed to this paper really is telling the story from the committee's perspective. And so given that pretty much, I think we have 10 questions, I think 7 of them were about GAO. Obviously, that's something that people are really intrigued by, and it would add a little bit of meat to that. And then once you know that, and potentially by talking to some folks at GAO, you get a better idea of where the extensions would be most fruitful. So that's my 2 cents.
Yeah, that makes sense.
Yeah, thanks so much, Jen. So I think that it's worth, GAO is one of those bodies which has really bipartisan confidence. And so in some sense, we're also invoking that remedy or that institution to kind of intervene in this world of kind of political back and forth, right? And so I think that's important. I also want to say, as to the exact mode of judicial review, it might be Administrative Procedure Act or otherwise. I feel pretty confident that a clawback of a salary that we would be able to overcome any kind of other kind of immunity issues that might otherwise apply with suing the government. So that's great. Well, this has been definitely a pleasure for me to engage with you, Jen, and to hear these wonderful questions. And I would just say that, this is, as we've said, not a perfect solution, not a complete solution, and not a solution that we thought we'd come to, but we think something that's really worth thinking about in this place that we are, as Mike's mentioned, of really extreme partisanship, where there really is constitutional hardball being played by the executive branch, and Congress seems to be not quite playing with the same level of strength.
And let me just reiterate that we thank the Levin Center. We're just honored and so pleased with the award. And I think the event we had today is just a great example of how you can bring, and you are bringing, the academic thinking face to face with people who know what's going on the ground, care about it, implement it. And already it's going to make our next work better. And so we very much appreciate your efforts on that part.
And thank you guys so much for an absolutely lovely presentation. I can't say enough good things about the paper. And I have to be honest, Kevin, it was kind of fun to be the one asking you questions. Full disclosure for those who are still on the call, Kevin was part of my dissertation committee. So yeah.
Harder
Okay.
getting them from you.
I don't know about that. So I thanks everyone for joining us, and we hope that you tune in for some of our future events, including we'll be having a symposium on infrastructure oversight, both the mechanisms to invest in infrastructure oversight, and then sort of what happens after the fact. So that will be happening in March, and I look forward to all future Levin events. Thanks again, everyone, for showing up.
Thank you so much.